pig in a waistcoat was found guilty of murder. Rats were given a lawyer who argued they couldn't attend court because of cats. And, believe it or not, a rooster was burned at the stake simply for laying an egg. These weren't scenes from a bizarre play. They were actual historical events where animals faced human justice. Court records detail how animals were arrested, imprisoned, and provided with legal counsel before facing judges and sometimes executioners. Number 12. The elephant that faced a town's fury. In September 1916, in the small town of Erwin, Tennessee, an elephant named Mary became the center of a tragic event. Mary was a 5-ton Asian elephant, a star attraction for Sparks' world-famous show's circus. On September 11th, during a parade in St. Paul, Virginia, a man named Red Eldridge, who was an inexperienced, newly hired assistant elephant trainer, reportedly prodded Mary behind her ear with a bullhook when she reached for a piece of watermelon. Mary reacted. She grabbed Eldridge with her trunk, threw him against a drink stand, and then stepped on his head. Eldridge died instantly. Crowd, initially excited for the parade, turned into an angry mob. Shouts of "Kill the elephant" filled the air. The local blacksmith tried to shoot Mary, but the bullets from his small caliber rifle seemed to have little effect on her thick hide. The circus owner, Charlie Sparks, knew he had a serious problem. Towns began to cancel the circus performances, fearing Mary's presence. To save his circus from ruin and to appease the public, Sparks made a difficult decision. The town of Erwin, Tennessee, agreed to let the circus perform if Mary was dealt with. It was decided that Mary would be publicly executed. On September 13, 1916, Mary was transported by rail to Erwin. A crowd of over 2,500 people, including children, gathered to watch. The initial plan was to kill Mary by crushing her head between two facing locomotives, but this was deemed impractical. Another idea was electrocution, but the town lacked sufficient power. The method chosen was hanging. A 100-ton derrick car with a crane, normally used for lifting railway carriages, was brought in. Chain was placed around Mary's neck. The first attempt to lift her was a horrifying failure. Chain snapped, and Mary fell to the ground, breaking her hip. A spectator reportedly ran up and tried to cut off her trunk with a knife, but was stopped. A stronger chain was found, and Mary was lifted again. This time, the chain held, and Mary was hanged for about 30 minutes until she was pronounced dead. A veterinarian present confirmed her death. She was then buried beside the railroad tracks. The event was documented in photographs. While not a formal trial with a judge and jury in a courtroom, Mary's fate was decided by a combination of public outcry, fear, and economic pressure, leading to a planned and public execution. Number 11. The monkey, hanged as a French spy. During the Napoleonic Wars in the early 19th century, a strange event is said to have occurred in the coastal town of Hartlepool, England. Anti-French sentiment was extremely high across Britain. The story goes that a French ship, a chasse-marée, a type of French coastal vessel, was wrecked off the Hartlepool coast during a storm. The only survivor to make it ashore was the ship's monkey, which was reportedly wearing a miniature French military uniform, perhaps for the amusement of the crew. The fishermen of Hartlepool, who had never seen a monkey before, nor a Frenchman, were puzzled. They found the creature on the beach, chattering in a way they couldn't understand. They supposedly held an impromptu trial on the beach. Unable to comprehend its strange sounds, and given its uniform, they concluded that the monkey must be a French spy. Some versions of the legend say they questioned the monkey, and when it failed to answer or made noises they interpreted as foreign, their suspicions were confirmed. The fishermen, convinced of the monkey's guilt as an enemy combatant sentenced it to death. The monkey was reportedly hanged on the beach from the mast of a fishing boat, or a gallows quickly assembled for the purpose. This tale became a famous part of Hartlepool's folklore. People from Hartlepool are sometimes affectionately known as monkey hangers. While the story is widely known and celebrated in the town's culture, with a football club mascot named Angus the Monkey, historical evidence for the actual trial and hanging is scarce. Most historians consider it a legend, possibly an invention of a popular song by Ned Corvin in the 19th century, or a story that grew over time to mock the perceived backwardness or extreme patriotism of provincial communities. However, the tale persists as a powerful local legend. It speaks volumes about the fear and paranoia that can grip communities during wartime, even if the accused spy was only a small, bewildered animal. Number 10. The snails that were officially banished. In 1487, the town of Macon in the Burgundy region of France faced a serious agricultural problem. Snails were devastating the vineyards and crops. The situation became so dire that the ecclesiastical authorities were called upon to intervene. This wasn't unusual for the time. Church courts often dealt with animal pests when they were perceived as a divine scourge or a demonic infestation. The snails were formally summoned to appear before the ecclesiastical court. A legal process began, much like one involving human defendants. The snails were given a chance to defend themselves, though how this was practically managed is not detailed in surviving records. Beyond the fact that the court appointed an official to represent their interests, or at least to argue why they might be present, the case dragged on. Court deliberated on the matter. Eventually, a verdict was reached. The snails were found guilty of causing damage and disturbance. As punishment, they were not executed, but were ordered to leave the affected areas of the Diocese of Macon. The sentence was proclaimed publicly. The snails were given a specific timeframe within which they had to depart. This order of banishment was a common sentence for pest animals in ecclesiastical courts. It was often accompanied by prayers, processions, and religious ceremonies designed to enforce the court's decree through divine power. The idea was that the animals, being part of God's creation, would obey a divinely sanctioned order. If they failed to leave, they could then be subject to further spiritual punishments, such as anathematization or excommunication, effectively cursing them. The records of the Macon snail trial illustrate how seriously these legal proceedings against animals were taken, and the kind of solutions that were sought through the church's authority. Number 9. The caterpillars put on trial in Troyes. In the year 1516, in the French town of Troyes, an infestation of caterpillars threatened the local harvest. These tiny creatures were causing significant damage to crops, leading to fears of famine and economic hardship. The frustrated villagers turned to the ecclesiastical court for help, a common practice when dealing with widespread pestilence that seemed beyond human control. Caterpillars were formally put on trial. The church officials initiated legal proceedings against the insects. A summons was issued, calling for the caterpillars to appear before the court to answer the charges of damaging the community's food supply. Of course, the caterpillars did not physically appear in court. However, the legal fiction was maintained. As was customary in such animal trials, the caterpillars were appointed a legal representative, a lawyer, to argue on their behalf. This was done to ensure that the trial followed due process, at least in theory. The lawyer's role was to present any possible defense for the caterpillars, perhaps arguing that they were also God's creatures and had a right to sustenance, or that their presence was a punishment for human sins. Trial proceeded with all the formalities of a human court. Arguments were heard, and evidence of the damage caused by the caterpillars was presented. After due deliberation, the court typically would issue a sentence. In many such cases, involving insect pests, the sentence involved an order for the creatures to depart from the affected area by a certain date. If they failed to comply, they could be subjected to anathema or excommunication, a formal curse from the church. These pronouncements were read out publicly and were believed to carry spiritual weight that would compel the animals to obey or suffer divine retribution. Troyes caterpillar trial is one of several such cases recorded in France during the 16th century, reflecting a worldview where the legal and spiritual realms were deeply intertwined even in matters of pest control. Number 8. The flies that met a saint's curse. In the 12th century, around the year 1121, a rather unusual event involving flies took place at the Abbey of Foigny in France. The renowned Cistercian abbot Bernard of Clairvaux was visiting the abbey, which he had helped to found. At the time of his visit, the newly built church was reportedly plagued by an overwhelming swarm of flies. The sheer number of flies was causing a great nuisance, disturbing the monks and disrupting the sanctity of the church services. Their constant buzzing and presence made concentration and prayer difficult. The situation was so bad that Bernard of Clairvaux was asked to intervene. Known for his piety and spiritual authority, it was hoped he could do something about the infestation. According to the accounts of his life, written by his contemporaries, Bernard, annoyed by the persistent flies, uttered a simple but powerful phrase. He reportedly declared, "Excommunico is," which translates to, "I excommunicate them." This was a formal ecclesiastical censure, typically used against heretics or grave sinners, cutting them off from the church. Applying it to flies was, to say the least, unusual. The story goes that the effect of his pronouncement was immediate and dramatic. The very next morning, all the flies in the church were found dead. They were reportedly so numerous that they had to be shoveled out of the building. This event was recorded as one of the miracles performed by Saint Bernard, demonstrating his spiritual power and the belief that even the smallest of creatures were subject to divine authority and the pronouncements of the church. While not a trial in the sense of a courtroom proceeding with lawyers and judges, the act of excommunication was a formal legal and spiritual sentence issued by a figure of ecclesiastical authority, and in this case it was directed squarely at the offending flies, leading to their demise. Number 7. The horse tried alongside its owner for witchcraft. Animal trials often involve domestic animals accused of participating in crimes with humans or of being tools of demonic forces. A case that touches on this theme occurred in 1603 in Paris, involving a horse named Van der Gallien's horse, though the details are sometimes conflated with other similar instances. More broadly, horses were sometimes implicated in witchcraft or sorcery trials alongside their owners. If a person was accused of witchcraft, their animal familiars or even their working animals could be seen as complicit or as instruments of their evil deeds. In some instances, if a horse displayed unusual intelligence or performed extraordinary feats, it might arouse suspicion. People might believe it was bewitched or possessed by a demonic spirit, especially if its owner was already under suspicion for sorcery. In such cases, the animal could be arrested and imprisoned along with its owner. During the trial of the human, the animal's behavior and abilities might be presented as evidence of supernatural involvement. If the owner was found guilty of witchcraft, the animal could also be condemned. The punishment for animals convicted in such circumstances was often the same as for their human counterparts, typically death. Horses, like other animals implicated in serious crimes, could be hanged or burned at the stake. The execution was often public, serving as a warning to others. The legal basis for trying animals, especially for crimes like witchcraft, stemmed from a belief that animals could be agents of the devil or could be possessed. Court proceedings, even when involving animals, aimed to follow a semblance of due process, reflecting the legal understanding of the time. These trials highlight how deeply the belief in witchcraft and demonic influence permeated society, extending even to the animal kingdom. Number 6. The dog, accused in the Salem witch trials. The Salem witch trials of 1692 in colonial Massachusetts are infamous for the hysteria and injustice that led to the execution of 20 people and the deaths of several others in prison. Amidst this dark chapter, at least one animal, a dog, was also caught up in the accusations of witchcraft and met a grim fate, according to historical accounts. Specifically, the records kept by ministers like Deodat Lawson and John Hale, who documented the events. A dog was implicated in the afflictions suffered by some of the bewitched girls. In one instance, a girl experiencing convulsions and fits claimed that the specter of a man, along with a thing like a dog with a chain, was tormenting her. The specific dog in question was linked to John Bradstreet of Andover, who himself was accused of witchcraft, partly because he was said to be able to command dogs with strange powers. His dog was accused of bewitching several people. More directly, another dog, belonging to a man named Joseph Ballard, whose wife was afflicted, or possibly associated with the afflicted Mercy Short, was suspected of being a familiar or an agent of witchcraft. The afflicted individuals would claim that the dog was biting or tormenting them, or that its spectral form was appearing to them. Based on these accusations, the dog was shot and killed. This act was not the result of a formal courtroom trial for the dog itself, in the way some medieval European animal trials were conducted with defense lawyers. Instead, it was a more summary execution, driven by the prevailing fear and the belief that animals could be instruments of the devil or witches' familiars. The execution of the dog in Salem demonstrates the extent of the paranoia. The belief system at the time held that witches often employed animals, known as familiars, like cats, dogs, or birds, to carry out their malevolent deeds. Killing an animal suspected of being a familiar was seen as a way to disrupt the witch's power or to confirm the presence of witchcraft. The dog's death is a small but telling detail in the larger tragedy of the Salem witch trials. Number 5. The moles that faced a bishop's wrath. In the early 12th century, specifically around the year 1120, Bishop Norbert of Xanten, who later became Saint Norbert, founder of the Premonstratensian order, found himself dealing with an agricultural menace in the Diocese of Lyon, France. Fields in the region were reportedly being overrun by moles. These small burrowing mammals were causing extensive damage to crops and pastures by tunneling through the earth, disrupting root systems and creating molehills that made farming difficult. The problem was severe enough that it was brought to the attention of Bishop Norbert. In medieval Europe, when natural disasters or pest infestations struck, people often sought intervention from the church. Such events were sometimes interpreted as signs of divine displeasure or demonic activity. The bishop, as a figure of spiritual authority, was called upon to address the mole plague. Unlike some other animal cases that involved formal court proceedings, Bishop Norbert's response to the moles was more direct, yet still within the realm of ecclesiastical action. He didn't convene a trial for the moles, but he did take action against them using his spiritual authority. According to historical accounts, Bishop Norbert went to the affected fields and formally cursed the moles. This curse was an imprecation, a solemn prayer or declaration calling for harm or banishment upon the creatures. It was believed that a powerful spiritual leader, like a bishop, could command nature or expel troublesome animals through such divine intercession. The chronicles that record this event state that Bishop Norbert's curse was effective. Following his pronouncement, the moles reportedly either died off or departed from the lands they had been plaguing, much to the relief of the local farmers. This incident is often cited as an example of an ecclesiastical action against animals, though it falls short of a full trial. It reflects the belief that the church had power over all of creation, including animals, and could intervene to protect communities from natural afflictions through spiritual means, such as blessings, exorcisms, or in this case, a curse. Number 4. The Weevils that were offered their own land. One of the most elaborate and well-documented animal trials involved a group of weevils in the village of Saint-Julien, near Macon in France. This case spanned several decades, starting around 1545 and not fully concluding until 1587. The weevils, specifically vine weevils or snout beetles, were accused of causing extensive damage to the local vineyards, which were crucial to the village's economy. The villagers, desperate to save their crops, initiated legal proceedings against the insects in the ecclesiastical court. The weevils were formally summoned to appear before the judge. As they predictably failed to show up the court-appointed lawyers to represent them. This was a key feature of many animal trials intended to ensure fairness and proper legal procedure. Two lawyers, Antoine Filiol and Pierre Rimbaud, initially represented the weevils. The trial involved lengthy arguments and legal maneuvering. Prosecution detailed the damage caused by the weevils and demanded their expulsion. The defense lawyers for the weevils argued passionately on their behalf. They contended that the weevils, as creatures of God, had a right to exist and to eat. They also raised procedural objections, such as questioning the validity of the summons if all individual weevils had not been properly notified. At one point, a compromise was proposed. The village would allocate a specific plot of land outside the vineyards for the weevils to inhabit, with the understanding that they would stay there and leave the crops alone. This offer was formally made. However, the weevils' lawyer inspected the designated land and rejected it, arguing that it was barren and unsuitable for the weevils' sustenance. Case dragged on for years, with various delays and appeals. Court issued admonitions and threats of excommunication against the weevils if they did not cease their destructive activities or relocate. The surviving records provide a fascinating glimpse into the legal thought of the time, which seriously entertained the idea of animals having rights and being subject to legal processes. The final outcome isn't entirely clear from the fragmented records, but the sheer length and complexity of the weevil trial of Saint-Julien make it a naked example of animal jurisprudence. Number 3. The Rats of Auton and their clever lawyer. In 1510, in the French town of Auton, a peculiar legal case unfolded. The local rat population was accused of a serious crime, wantonly destroying and consuming the barley harvest. The damage was so significant that the ecclesiastical court decided to take action, initiating a formal trial against the rodents. Public prosecutor was appointed to represent the interests of the people of Auton. The rats, as defendants, were also assigned legal counsel. This role fell to a brilliant and renowned lawyer named Bartholomew Chassenny, also spelled Chassenny or Cassanuz. Chassenny took his responsibility very seriously, employing ingenious legal tactics to defend his non-human clients. When the rats failed to appear in court for the first summons, Chassenny argued that the summons was invalid. He contended that his clients were widely dispersed throughout the countryside, living in numerous villages, and a single summons was insufficient to reach all of them. He argued that each individual rat, or at least each community of rats, needed to be properly notified. Court agreed, and new summonses were ordered to be read from the pulpits of all parishes inhabited by the rats. When the rats still didn't appear for the rescheduled hearing, Chassenny had another argument ready. He claimed that the journey to court was too perilous for his clients, pointed out that the rats would have to travel long distances, and their mortal enemies, the cats, were lying in wait ready to ambush them. He argued that his clients could not be expected to risk their lives to attend the trial. Therefore, he requested that the court guarantee safe passage for the rats, perhaps by ordering the cat owners of Auton to confine their pets. Court records detail these arguments. Chassany's defenses were based on established legal principles, highlighting the procedural thoroughness that these animal trials sometimes aimed for. His arguments were so effective in causing delays and highlighting procedural complexities that the outcome of the trial itself is not entirely clear from historical sources. Some accounts suggest the case was eventually dropped or indefinitely postponed. Bartholomew Chassany later became famous for his treatise on animal law, Concilium Primum de Processu contra Animalia, which discussed the legalities of trying animals. Number 2. The Sow and Piglets tried for murder. One of the most frequently cited examples of an animal trial is the case of a sow and her 6 piglets in Savigny, France, in 1457. The charge was horrific. The sow was accused of murdering a 5-year-old boy named Jehan Martin. According to the records, the sow had attacked the child, inflicting fatal wounds to his face and arm. Following this tragic event, the sow was arrested and imprisoned in the local jail, just as a human criminal would have been. A formal trial was conducted in the seigneurial court, presided over by the local magistrate. The sow was the primary defendant, but her 6 young piglets were also implicated, presumably for being present at the scene or for partaking in the attack, although their exact role is less clear. Court proceedings followed the legal customs of the time. Evidence was presented, likely including testimony from witnesses who saw the attack or found the child. The sow was brought before the court to face her accusers. After hearing the case, the court found the sow guilty of murder. The sentence was death by hanging from a gallows. The execution was carried out publicly. Adding a bizarre and symbolic touch, the sow was reportedly dressed in human clothes, specifically a man's waistcoat, for her execution. This act of dressing the animal might have been intended to emphasize its culpability in a human-like crime, or to make the execution a more striking spectacle. The fate of the 6 piglets was different. While they were initially found guilty alongside their mother, their case took a turn. The prior of a local convent and the Seigneur de Savigny interceded on their behalf. They argued that the piglets were too young to be held fully responsible for their actions and had merely followed their mother's bad example. Court considered this plea. In a display of what might be termed leniency, or perhaps a recognition of their lesser culpability, the piglets were acquitted due to their youth and the lack of direct proof that they had participated in the killing. Court records of this trial, including the expenses for the sow's imprisonment and execution, including the cost of the rope and the executioner's fee, have survived, providing a detailed account of this strange legal episode. Number 1. The Rooster burned for an unnatural crime. In the city of Basel, Switzerland, in the year 1474, a truly extraordinary trial took place. The defendant was not a human or even a mammal, but a rooster. The charge against this unfortunate bird was equally astounding. It was accused of committing the unnatural crime of laying an egg. In medieval European folklore, an egg laid by a rooster was believed to be highly dangerous. Such an egg was thought to be capable of hatching a cockatrice, a mythical serpent-like creature with a deadly gaze often associated with evil and witchcraft. The presence of a rooster's egg was therefore seen as a terrible omen and a sign of demonic influence. When a rooster in Basel was discovered to have apparently laid an egg, the city authorities took the matter with utmost seriousness. The rooster was arrested, and a formal trial was convened. Court proceedings were conducted with all the gravity of a human trial. The rooster was assigned a lawyer to defend it against the charges. Prosecution argued that the rooster, by laying an egg, had acted against nature and was therefore an instrument of the devil. The defense lawyer reportedly argued that the act of laying an egg was involuntary and that the rooster could not be held responsible for an unintentional biological anomaly. He may have also argued that there was no explicit law against roosters laying eggs. Despite the defense, the court found the rooster guilty. The verdict was that the rooster was a demon in disguise, or that its act was instigated by Satan. The sentence was death. The rooster, along with the accursed egg it had laid, was taken to a public square. There, it was solemnly executed by being burned at the stake, a punishment typically reserved for heretics and witches. A large crowd gathered to witness the execution. The burning of the rooster and its egg was intended to purify the community of the evil they represented and to prevent the hatching of a cockatrice. The detailed records of this trial, including the arguments and the sentence, have survived, making the Beisel rooster trial one of the most famous and bizarre examples of animals being subjected to human legal systems for perceived crimes against nature and God.